Greetings everyone. I'm Ariba Naseem. This is week 11 and the topic for our discussion today is the offense of cruelty, and we will be conducting a detailed legal discussion of sections 85 and 86 of Bharatiya Nyaya Sanhita 2023. For decades, the discourse on matrimonial cruelty in India has been legally anchored to one provision, that is Section 498A of the Indian Penal Code. It was a law born from necessity aimed at protecting women from the scourge of harassment and cruelty within the matrimonial home, often linked to dowry. With the advent of the BNS, Bharatiya Nyaya Sanhita, our new penal code, the legislature has not abolished this offense. On the contrary, it has reinforced its importance by giving it a new and arguably clearer structure. This is what we will dissect today. Please take a look at the slide. We will explore the text of these new sections, understand their essential ingredients, and examine the vast body of case laws which are critically relevant and has shaped our understanding of cruelty over the last few decades. We will also discuss the procedural outline of offense and its nature. Let's move on to the next slide and begin. Cruelty, ideal versus reality. Let's talk about the ideal situation versus the ground reality. In our society, marriage is widely revered as a sacred bond. It is more than a legal or a social contract. It has a deep spiritual, moral, and often divine significance. However, the harsh reality is that despite this ideal notion, many women face cruelty and torture within their homes. The perpetrators of this crime are usually the husband or his relatives, often the very people entrusted with the woman's care within the boundaries of the marital home. The law we have on cruelty recognizes this grave issue and aims to protect women from such suffering and provide a mechanism to seek justice. The new legal structure. So let's begin by setting the context. Section 498A of the Indian Penal Code 1960 was a single, comprehensive, and powerful provision. It defined the offense, it prescribed the punishment, and in its explanation, it defined what cruelty legally meant. The Bharatiya Nyaya Sanhita, in its redrafting, has taken this single provision and bifurcated it. What once was Section 498A is now spread across two sections, Section 85 and Section 86. So earlier, the provision was contained in Section 498A of Indian Penal Code. Now, it has been bifurcated and it is there in Section 85 and 86. This bifurcation isn't just a numbering. This bifurcation isn't just a renumbering, it is a structural reorganization. The fundamental principles, the ingredients, and the judicial precedents of Section 498A are not discarded in the new law. They are directly inherited by Section 85 and 86. This slide on your screen gives you a clear visual breakdown of the change. On the left, you see the old law, IPC Section 498A. As it was mentioned, it was an all-in-one provision. It stated that if a husband or his relative subjected a woman to cruelty, they would be punished. Then, in its explanation at the bottom, it defined cruelty. On the right, we have the new law, the BNS, Bharatiya Nyaya Sanhita. Section 85 is now the operative provision. It gives the punishment. It is the charging section. Section 86 is the definitional provision. It has given the definition of cruelty. Please take a look at the slide on your screen. Let's move on to the next slide. Cruelty defined. Cruelty is defined in Section 86 of Bharatiya Nyaya Sanhita 2023. So we will take up Section 86 first and then we will move on to Section 85. First, deal with the first part of the definition of cruelty found in section 86. Section 86 has two parts, part A and part B. We will first deal with part A. Part A says, for the purpose of section 85, cruelty means any willful conduct which is of such a nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb or health. After health, there's a word after health or danger to life, limb or health, whether mental or physical, of the woman. Section 86 provides a clear definition of cruelty for the purpose of Section 85, which addresses offences against women. This section outlines two main forms of cruelty. Part A, which we are discussing here, is about willful conduct that is severe enough to drive a woman to consider suicide, or the conduct causes grave injury or danger to the woman's life, limb, or health. Health here includes both mental as well as physical. Mental as well as physical. This is what we call part A of the definition. This is critical. It has nothing to do with the dowry part. This is about pure willful cruelty. It is any conduct so severe that it threatens the woman's life or health. Dear learners, we must note that by inclusion of term whether mental or physical, the law explicitly recognizes that mental cruelty can be as grave or even graver than physical cruelty. It acknowledges that conduct likely to drive a woman to suicide is the pinnacle of such cruelty. Please read the language of section 86 part A again before we move to part B of section 86. The definition in section 86 continues with part B. I'll read the clause B first. It says, harassment of women where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security, or is on account of failure by her or any person related to her to meet such demand. This is the second and most commonly known phase of section 498A, now section 86. This is the dowry harassment part. Notice the precise language of this section. Notice the precise language of this part of the section. The harassment is for a specific purpose. The purpose is to coerce her or her family to meet an unlawful demand. Coerce her or her family or any person related to her, that is her family, to meet an unlawful demand. Or it is harassment that happened because she or her family failed to meet that demand. Thus, this section directly targets the evil of dowry. This is the dowry part. The two parts of cruelty, section 86. The concept of cruelty mainly consists of two parts. First, we have part 1, that is the willful conduct. Part 1, willful conduct. This covers act. The concept of cruelty mainly consists of two parts. First, we have part 1, that is the willful conduct. Please look at the slide. I'll read the slide for you. Please look at the slide. I'll read it for you. This willful conduct. This covers acts that are a danger to life, limb or health. It is not necessary to prove a dowry demand. It includes conduct likely to drive her to suicide, conduct likely to cause grave injury or danger to mental or physical health. This is the danger part. This is for acts of physical violence, grave mental torture, or persistent abuse that is so severe it endangers the woman's life, limb, or mental or physical health. A key aspect here is that it must be willful conduct, not accidental or trivial. Second, we have part 2, that is the harassment part. Look at the slide, please. Harassment, dowry related. This is specific to unlawful demands. It includes harassment to coerce her or her relatives for property or security, or harassment on account of failure to meet such demands. This is the dowry part. The earlier part was the danger part. This is specific. It is the harassment for or an account of an unlawful demand. It is vital to understand that a person can be convicted under Part 1 even if there is no dowry demand at all. And a person can be convicted under Part 2 for harassment even if it does not rise to the level of endangering her life, though the reality is it often does. The prosecution only needs to prove one of these two parts. Prosecution only needs to prove one of these two parts. Punishment for cruelty. Punishment for cruelty is given under Section 85 of BNS. Let's read the bare text of the main offense. Section 85. Husband or relative of husband of a woman subjecting her to cruelty. Whoever, being the husband or the relative of the husband of a woman subjects such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years and shall also be liable to fine. This is the core of the offense. The language is precise here. It identifies who can be an offender or perpetrator, that is the husband or his relative. It also identifies who's the victim. It is always a woman, the offender's wife, and what the act is, the act of cruelty. It then lays down the punishment, 3 years plus fine. Imprisonment as well as fine. 3 years is the maximum punishment, so it is up to 3 years plus fine. You will notice here that the word cruelty is used but not defined in this section. It is defined in section 86, which we have discussed earlier. Essential ingredients of section 85 and 86. So, as per section 85 and 86 together, if a prosecutor wants to secure a conviction under section 85, they must prove 3 essential ingredients beyond a reasonable doubt. First, the victim must be a married woman. This law is specific to the matrimonial context. Second essential is that the accused must be the husband or relative of the husband. This can include the mother-in-law, father-in-law, brother-in-law, etc. The term relative has been a subject of much litigation, but it generally means related by blood or marriage. The third essential is that the act must be there, the actus reus, and the accused must have subjected the woman to cruelty. And what is cruelty? It has not a common parlance meaning. It has a legal meaning as defined in section 86. The prosecutor must show that the alleged act falls squarely within either part A, that is the willful conduct, or part B, that is the dowry harassment. So these are the 3 essentials of section 85 and 86 which must be proved to secure a conviction under the offense of cruelty. Illustrations. Let's have a look at illustrations. Illustration 1. It is based on willful conduct to cause grave injury to life and limb. X. Please look at the slide. X. A husband repeatedly and severely beats his wife. So X beats Y. X is the husband here and Y is his wife, causing her frequent bruises and fractures, and threatens her life if she speaks to anyone. This is willful conduct causing grave injury or danger to her life, limb, and physical health. This would come under the purview of cruelty. Illustration 2. Illustration 2 is based on willful conduct to drive women to commit suicide. H, husband, and his mother, M. I'll first erase the H and his mother M. Constantly subject W to extreme verbal abuse. W, his wife, and her daughter-in-law. Daughter-in-law or wife. Constantly subject W to extreme verbal abuse, humiliation, and malicious character assassination in front of guests, knowing that W has a history of severe depression and is showing signs of suicidal ideation. This would come under cruelty. Why? Because here is extreme verbal abuse, humiliation, malicious character assassination in front of people, and there is knowledge that W has a history of severe depression and is already showing signs of suicidal ideation. H and M here would be liable to cruelty. H and M here would be liable for the offense of cruelty. Illustration 3. Willful conduct causing grave danger to physical health. D. A daughter-in-law is willfully and systematically denied food, proper medical care when ill, and is locked in a room by her mother-in-law M as a means of control and punishment. Here M, the mother-in-law, willfully and systematically denies food, proper medical care to her daughter-in-law and also locks her in a room as a means of control and punishment. So the conduct of mother-in-law here is causing grave danger to her physical health. This would also come under cruelty. The mother-in-law would be liable for the offense of cruelty. Illustration 4. Harassment to meet unlawful demand for dowry. X, husband, stops speaking to his wife, and Y, mother-in-law, constantly locks her in her room and withholds food, stating explicitly, "You will not be treated like a daughter until your father sends the money for the new car." Here, the X and Y, both mother and son, constantly lock the victim in her room and withholds food and also demand money from her for the new car. So this is harassment to meet unlawful demand for dowry. The demand for new car, the demand for money for the new car is unlawful demand. This is harassment, and this would also come under cruelty. Both the husband and the mother would be liable for cruelty. So let's move on and look at the key case laws in cruelty. Since the definition of cruelty is not static, it has been interpreted and shaped by our judiciary for decades. These three cases are fundamental to understand the legal concept of cruelty. The first one is Manju Ram Kalita versus State of Assam. Please look at your screen. This case is from the year 2009. In this case, the wife alleged that she was subjected to mental and physical torture by her husband. The wife left the matrimonial home in 1993 due to alleged cruelty and started living with her father. The complaint, FIR for cruelty, was lodged much later in 1997 after the wife discovered the husband's second marriage. So the wife left her matrimonial home in 1993 and the complaint was lodged in 1997. The prosecution failed in this case to provide substantial evidence of continuous persistent cruelty or cruelty committed in close proximity to the lodging of complaint in 1997. the Supreme Court noted the significant time gap from 1993 to 1997 and the lack of continuous evidence. It emphasized the, the court emphasized that petty quarrels do not constitute cruelty under Section 498A. Now, the corresponding BNS section. The court also emphasized that it must be a willful act or conduct of grave and persistent nature. So, by this case, it is clear that cruelty must be persistent and it is a series of acts committed to the committed. So, in this case, the Supreme Court set aside the conviction and sentence of the husband under Section 498A of IPC, which is now Section 85 and 86 of IPC. The Supreme Court here provided a crucial clarification. Cruelty under this section is not the same as cruelty in a divorce proceeding. It is a criminal offense. It does not mean petty quarrel, trivial differences, or day-to-day marital disagreements. The court held it must be a conduct of grave and persistent nature, and this case prevents the trivialization of the section. Another important case is of Samar Ghosh versus Jaya Ghosh. This case is from 2007. While this was a divorce case, it provides the most exhaustive analysis of mental cruelty in Indian law, which is frequently cited in 498A cases. The court said, mental cruelty is a question of fact. The court said, mental cruelty is a question of fact and there can be no straitjacket formula. It depends on the social strata, the education, the background, and the sensitivities of the party. What is cruelty for one person may not be for another. The next important case is of Shobha Rani versus Madhukar Reddy. This is a foundational case. The court made it crystal clear that a demand for dowry is in itself an act of cruelty. A demand for dowry is in itself an act of cruelty. The act of demanding dowry implies a threat and is a source of harassment. Therefore, it falls squarely within the definition. So these are the three important cases to understand the concept of cruelty. Then we have an important case to understand the meaning of the term relative of the husband. The case we have here is U. Suvitha versus State by Inspector of Police. The case involved a wife, the complainant, and her husband. The petitioner in this case, U. Suvitha, was the woman with whom the husband was allegedly having an extramarital affair. The wife filed a complaint. The wife filed a criminal complaint against her husband and others, including U. Suvitha, alleging offences under Section 498A IPC, cruelty, and other sections. The specific allegation against U. Suvitha was that she was the husband's concubine and was instigating the husband to torture the wife, thus subjecting the wife to cruelty. U. Suvitha filed a petition seeking to discharge herself from the case, arguing that she was not a relative of the husband as defined by Section 498A IPC and therefore the charge against her under that section was not legally sustainable. The Madras High Court refused to discharge U. Suvitha, holding that a paramour or concubine could be considered a relative for the purpose of Section 498A. An appeal was filed, and the Supreme Court noted that the term relative is not specifically defined in IPC. Therefore, it must be assigned a meaning that is commonly understood in law. The Honorable Court also noted that the word relative brings within its purview a legal status. Such a status must be conferred either by blood, marriage, or adoption. The decision by the court in this case clarified the individuals without a legal familial link cannot be charged under this section. Consequently, the criminal proceedings against Yusuvita under section 498A were quashed. Then we have another important case, Satish Kumar Batra versus State of Haryana. The Satish Kumar Batra case provides crucial guidance for courts in dowry cruelty prosecutions, emphasizing that the potential misuse of Section 498A does not undermine its validity, but courts must apply meticulous evidentiary rigor, carefully segregating proof facts from general or vague allegations, especially when convicting the husband's relative. It was also observed in the case that the mere possibility of abuse does not render legislation invalid, and it is presumed that a law will be administered and applied fairly and impartially unless proven otherwise. So let's move to procedural outline. Let's have a look at this. Please look at the slide. Beyond the bare text, we must understand the procedural nature of this offense as it is what gives it teeth. The offense under section 85 is cognizable. Cognizable offense is a type of offense where a police officer has authority to arrest the accused without a warrant and initiate an investigation without a warrant. Here, the offense of cruelty is cognizable, but it is with a condition. It is cognizable only if the information relating to the commission of the offense is given to an officer in charge of police station by the person aggrieved by some offense, or by any person related to her by blood, marriage, or adoption, or if there is no such relative, by any public servant belonging to such class or category as may be notified by state government in this behalf. So generally cognizable offences are those offences in which the police officer has authority to arrest the accused without a warrant. But here under cruelty, this offense is cognizable with a condition, and the condition is there must be an information relating to commission of the offense. It must be given to an officer in charge of the police station, officer in charge of a police station by the person, by whom? By the person aggrieved by the offense, or by any person related to her by blood, marriage, or adoption, or if there is no such person, by any public servant belonging to such class or category as may be notified by state government in this behalf. Non-bailable. Cruelty is non-bailable in nature. This means bail is not a matter of right. The accused must apply to court and the judge will decide based on the facts and circumstances. Non-compoundable. Non-compoundable. Cruelty is a non-compoundable offense. Cruelty is a non-compoundable offense. This is very important. It means that even if the wife and husband later decide to compromise, the case cannot be legally withdrawn or compounded. This is very important. It means that even if the wife and husband later decide to compromise, the case cannot be legally withdrawn or compounded. The state is the prosecutor and the offense is seen as a crime against society, not just individual. Dear learners, please note that to check if an offense under the Bharatiya Nyaya Sanhita 2023 is compoundable or not, you should refer to section 359 of Bharatiya Nagrik Suraksha Sanhita BNSS 2023, which contains a specific table listing all the compoundable offences and the person entitled to compound them. Furthermore, even under these compoundable offences, some of the offences can only be compounded only with the permission of the court. Anyway, The strict procedural regime for Section 85 has unfortunately led to allegations of misuse. The Supreme Court, in cases like Sushil Kumar Sharma versus Union of India, has acknowledged this. While upholding the law's constitutionality, the court has cautioned against its misuse, sometimes referring it to as legal terrorism when husbands' entire families, including distant relatives, are roped into a complaint. This brings us to the single most important procedural case in the history of this law, Arnesh Kumar vs. State of Bihar, 2014. This case is the Supreme Court's direct response to the problem of misuse and automatic arrest. The court was faced with the reality that in Section 498A cases, the moment an FIR was filed, police would often arrest the husband and his entire family, putting them in jail before any investigation. The Supreme Court gave this a pause. It issued mandatory guidelines for all police officers in the country. It said that for any offense where the punishment is 7 years or less, which Section 85 is, no automatic arrest can be made. The police must first issue a notice of appearance under Section 41A of the CRPC, now the corresponding section of BNSS. The police must record their reason why an arrest is necessary, and a magistrate must review and approve those reasons before ordering judicial custody. The Arnesh Kumar guidelines are now the law of the land. They are a crucial safeguard that balances the law's protective intent with individuals' right to liberty. To conclude our session on the offense of cruelty by husband or relative, let's recap the critical takeaways. The transition and the scope. First, the new legal structure under the Bharatiya Nyaya Sanhita has enhanced clarity. By separating the offense and the punishment into Section 85 and 86 and the detailed definition of cruelty, to conclude our session on the offense of cruelty by husband and relatives, let's recap the critical takeaway. The transition and the scope. First, the new legal structure under the Bharatiya Nyaya Sanhita has enhanced clarity. By separating the offense and the punishment into Section 85 and the detailed definition of cruelty into Section 86, the law is more structured. The core substance of the offense remains robust, covering both acts of physical and mental harm that endangers life or health, and critically, all forms of harassment tied to unlawful dowry demands. Judicial mandate. Case law jurisprudence has ensured judicial mandate. Case law jurisprudence has been instrumental in shaping the law's application. Cases like Manju Ram Kalita and Shobha Rani confirm that cruelty must be of grave and persistent nature. It is not intended to criminalize every marital discord, but rather to punish genuine malice and torture. The safety net. The law remains a powerful protective instrument. Its classification as a cognizable, non bailable offense is necessary to give it the teeth required to protect a vulnerable wife. However, the courts are aware of the potential for misuse. The landmark Arnesh Kumar guidelines ensure that this power is not arbitrary, mandating that police must justify every arrest and follow proper procedure, thereby protecting the innocent while still securing the rights of the genuine victim. Ultimately, Section 85 and 86 of the BNS represent a balanced legal framework, a powerful deterrent against matrimonial cruelty, guided by judicial wisdom to ensure its fair application. That's all for cruelty. Thank you.